G'day everyone, welcome to the Legal Studies Guide, video 3.2.5. In our video today, we'll be exploring avenues of dispute resolution, which we'll look at in a moment. Our quote is from Stephen King: "Amateurs sit and wait for inspiration, the rest of us just get up and go to work." Again, I've said this 1,000 times, but this whole idea of just keep turning up. Inspiration is there some days, it's not some others. Regardless of that, you just need to go to work, get it done, turn up, and the rest will hopefully come. So as I said, 3.2.5, institutions or avenues to resolve civil disputes. Sorry, 3.2.4, not 3.2.5. So what we're looking at here is, and the terminology used in the study design is institutions to resolve civil disputes, and particularly CAV and VCAT. So CAV being Consumer Affairs Victoria, and VCAT being the Victorian Civil and Administrative Tribunal. And from here on in, I will basically refer to them as CAV or VCAT. Effectively based on our skill as well, today we are trying to get to the idea of what institutions exist to help an individual resolve a civil dispute, and I'll put a disclaimer on this, outside of the courts. So all the stuff we'll be going into after this, such as pre-trial procedures, role of key personnel in a trial, etc., is all going to be related to what happens when you go to court. This is what institutions exist outside of court, and they are CAV and VCAT. So we'll start with Consumer Affairs Victoria. Basically, in a broad-based sense, taken from their service charter or from their website, Consumer Affairs Victoria is there to support businesses to uphold Australian consumer law. So basically, a consumer, for those of you who aren't aware, is anyone who purchases anything. So pretty much we are all consumers. When you're watching this, you've probably been a consumer at some point today. You are a consumer anytime you purchase something, and then you obviously intend to personally use that. So if you just buy a Big M from the local corner store or the supermarket, you are being a consumer, right through to if you buy a car, you are being a consumer. So CAV is there to make sure that businesses uphold consumer law, Australian consumer law. And this is effectively things like regulations or laws around refunds, faulty products, that sort of thing, and what a business has to provide you with as a result of that. They also deal with registering and licensing businesses. They help review consumer legislation because obviously they're working in this area. They'll make recommendations on consumer legislation to lawmakers. They do some education stuff. Particularly, they're a little bit like Victoria Legal Aid in the sense that you can ring them for advice on consumer issues if you are a consumer. So a lot of educating there. And if needed, they will conciliate disputes regarding consumer law. So they'll actually work with you and perhaps the business that you feel like you have an issue with, a dispute with, to try and come to a resolution. And that's central to what Consumer Affairs Victoria do. So Consumer Affairs Victoria have what's called a compliance approach. So I want to make this really clear, and this will come up as we go through it. Consumer Affairs cannot make binding orders. So Consumer Affairs Victoria cannot say you've got a dispute, you go to them and say this company won't give me a refund, perhaps, something as simple as that. Consumer Affairs can't contact them and say you have to give that person a refund. You are, we're making that order and you have to do it or you're in contempt. Consumer Affairs does not have that power. All they can do is, and why it is a conciliation type process, is all they can do is offer advice. So they can offer advice to businesses and say, hey, to resolve the dispute, we would recommend that you do this. And in doing that, they can reference consumer law. So, hey, the law actually says this about refunds. We would recommend that the best resolution for this dispute is if you give that person a refund. So if you go to Consumer Affairs with a dispute, perhaps against a business that you've purchased something from, in Consumer Affairs Victoria's compliance approach, they will first basically try and educate the business and say, hey, look, you might not have been aware, but in this situation, this is what you need to do. Say we're working through supplying a refund. Hey, consumer law says that you have to supply a refund. You might not have been aware. Let's educate you as a business. We may provide you with a formal written warning, but effectively, you need to comply with what we're telling you to do. Okay, so the reliance here is that with that education, the business will comply with what Consumer Affairs is asking. Say that doesn't work. Then Consumer Affairs might give the business an infringement notice. So this is a formal notice that says, hey, you're not complying. We're basically giving you an infringement notice. That would be a fine of some sort. And this is perhaps where the business has tried to comply, but hasn't been able to successfully do it. Probably wouldn't work in a refund sense, but might be around perhaps a business's policies on returns. If then we are still not seeing a resolution to the dispute, Consumer Affairs Victoria has this ability to basically publicise the fact that the business isn't following their requests and the business isn't following their recommendations. So these could be public notices, perhaps in the newspaper or on TV, that draw other consumers' attention to the fact that you might not want to purchase from this business. So this is perhaps where the business is purposefully not complying. Okay. Say then we still haven't got a resolution to this dispute. This is when, because Consumer Affairs cannot make binding orders, this is when you as an individual, despite Consumer Affairs providing infringement notices and publicly declaring that the business is perhaps not following consumer law, if you still haven't had a satisfactory resolution to your dispute, you will need to then go to the courts or VCAT, which we'll learn about in a moment, because that is who you need to make a binding order. Okay? Because effectively, Consumer Affairs can't do that. They can make recommendations, they can request, they can tell the business that under consumer law you should do this, but ultimately they can't make them do anything unless you go to the courts or VCAT. And then say if we go beyond that, then Consumer Affairs can take or can ask the prosecution to take criminal action against the business for breaching laws potentially around fraud or similar with their practices. Okay, so again, it is all about with Consumer Affairs them encouraging businesses to comply. So, hey, this is the law. We encourage you to comply. This is what we would suggest you do. But if that doesn't work, you as an individual to resolve your dispute will have to go to the courts or VCAT to get a binding order. And we'll look at when Consumer Affairs is appropriate shortly, because they're obviously not going to be appropriate if a business won't comply. And we'll also look at the types of consumer disputes they're appropriate for, because sometimes what Consumer Affairs will actually do is they'll send you off to another organisation to get your dispute resolved. So they're not actually able to resolve all disputes. There are lots and lots and lots of other government organisations, etc., set up to deal with it. So, for example, if it's a dispute you have as a consumer with a builder, you might ring Consumer Affairs and they might say, hey, look, we actually can't do any work on this. We would recommend you contact the Victorian Building Authority to resolve that dispute. So not everything falls under their jurisdiction as well. The second key listed institution in this dot point of the study design is VCAT, which is the Victorian Civil and Administrative Tribunal. And they have a service charter, which you can find on their website, that says pretty simply and pretty straightforward, we aim for service excellence by being cost-effective, accessible, informal, timely, fair, impartial, and consistent. So lots and lots of buzzwords there, but effectively, as we're going to go through in a minute, VCAT is a tribunal that can make binding orders that is, I suppose, an alternative to going to the courts to have your dispute resolved. And it aims to be an alternative that people want to use because it is cheaper, it is quicker, etc. So it comes down to these four things. It's timely, it's accessible and informal, it's cost effective, but they are still experts. They still provide fairness, impartiality, and consistency in line with expertise. So why is VCAT as an alternative institution to resolve a civil dispute low cost? Well, get rid of that. Look at this. Basically, if you go to the courts, and we'll look at a table in a moment, there's lots of ongoing costs you need to pay. So filing of individual pieces of evidence, of individual pieces of paperwork, solicitors, barristers, all of that. All of these what we call ongoing costs. Paying for your barrister to come in for any directions hearings, or solicitors, etc. Whereas generally at VCAT, what they'll ask you to do is just pay a one-off fee. So for small claims that are less than $15,000, there is only a standard fee of $204.90. And don't quote me on that, that might have gone up in the past 6 months or so. But effectively, one nominal fee, $204.90, and your dispute will get resolved with no ongoing costs. Further, if you're a concession card holder, it'll actually be free. Okay? And as I said, the Magistrates Court, which would deal with a $15,000 matter, might start from over $500 just in terms of filing fees, not to mention what you're paying for legal representation. So this is an example of the fees and costs in the Magistrates Court. This is from 1st of January 2017, and yeah, lots of things to unpack here, but just looking at the idea that $145 to put your claim in, filing fee to start a dispute worth between $10,000 and $20,000 is $460. Any certificates you need, $236. Any professional items you put in, $655, so on and so forth. So the costs quickly balloon versus $204.90. Further, the fee can be waived if it's going to cause financial hardship. Parties are able to represent themselves, so you might not need lawyers. And in some lists, you're not even allowed to have lawyers. Basically, this means that you aren't going to spend as much money to have your dispute resolved. VCAT is also more timely. Okay, generally it can hear things quicker than the courts because it doesn't have to go through the exaggerated pre-trial procedures that courts have. We'll learn about those in the next video, but that's things like pleadings, that's things like discovery. In VCAT, you can basically file to have your dispute resolved and have a hearing, and that's it. There's limited avenues for appeal, and hearings are generally shorter. So if you, say, lodge a dispute through the residential tenancies list, which is VCAT's most used list or busiest section of VCAT, which is disputes between tenants and landlords. Basically, you put an application in, you can get a hearing date within 2 weeks, which is pretty good to get something like that resolved rather than waiting to go through the courts. Most hearings take less than a day, limited appeals, as I said, so you can get your dispute resolved. But the key here is, and we're going to look at expertise in a minute, we are not sacrificing the binding nature of courts. So VCAT still hands down binding decisions, okay, that parties have to agree to. It just does it in a way that's quicker. Accessible and informal. Evidence is still given under oath. It has to be truthful, but it is much more relaxed in terms of you can tell your story as a witness, and you can basically have hearings conducted fully on documentary evidence, unlike the courts where all evidence has to be tested. So you're not bound by those really rigid rules of evidence and procedure that the courts are. This can make it more accessible for a party because it's less intimidating. It's easier to understand. They don't have to just respond to questions. They can just talk about what happened. Effectively, VCAT will want to try and resolve the dispute in a way that is helpful for both parties if they can. So VCAT will actually prioritize, and if you have a hearing at VCAT, an ultimate hearing, so VCAT hearing, that is judicial determination. Okay, that is the same as if you had your dispute resolved in a court. But what they will try and do, and they will prioritize the use of alternate methods. So VCAT may send you into a conciliation process, so they may send you into a mediation process first, to try and get you to resolve it without going to trial. Okay, without going to a hearing where that third party has to hand down a decision. So that's more accessible, it's more informal, it's less intimidating and stressful for parties. Finally, we'll get rid of all that stuff there. It basically tries to make the process of understanding and getting to court easier through things like use of SMS, enabling telephone video conferences, online hearings, etc., stuff that the courts just wouldn't do. Finally, experts. VCAT is staffed, the people who resolve the disputes, they're not judges, they're called VCAT members. And they are judicial officers. They can hand down judicial decisions. They have that power. And they are people who are experienced working in that list. Okay? So someone who might work in, say, dealing with financial disputes through VCAT might have used to have worked in the financial sector. Builders or a building section might be someone who used to work in building legislation or things like that. The idea is that the members who are handing down the judgments have expertise in a particular area of law and related disputes, so your resolution is going to be one that is just and fair. It will include lawyers, professionals, architects, engineers, medical practitioners, etc., to make sure that the decision is just, fair, and right. The skill here is that we need to discuss and justify the appropriateness of institutions used to resolve civil disputes, aka when would you go to CAV and when would you go to VCAT. This is the sort of question you might get asked. Discuss the appropriateness of VCAT as an institution used to resolve a dispute. And this is effectively kind of their strengths and weaknesses, but also just when you would want to use it and when you wouldn't. And VCAT's effectively for matters where money's a concern, where you're going to find the formality of the courts intimidating, and where you'd want your matter resolved quickly, such as residential tenancies, or just even more minor disputes with neighbours, with local businesses, etc., that you kind of just want to get out of the way without an exaggerated court process. Where VCAT isn't appropriate is, like, they can deal with some complex matters, obviously, and the level of money required doesn't matter. Like, VCAT can deal with multi-million-dollar issues. But if it is an extremely complex civil claim, we're talking like a massive representative proceedings, like a bushfires compensation claim or similar, you're going to want to use the formality of the courts for that. Also, if one party is likely to use expensive legal representation, obviously you might go to VCAT if you're going to go through a list where that's banned, but it might be more appropriate to use the court there to make sure that you are on equal footing, and that they can't, I suppose, blast through you in the more informal environment of VCAT. Consumer affairs. When is it appropriate and when is it not appropriate? Let's assume that question is adjusted to say, discuss the appropriateness of consumer affairs used as an institution used to resolve a civil dispute. Basically, any consumer complaints that fall under their jurisdiction is something that's appropriate for CAV to deal with, because they can try and get the business to basically follow the law and resolve your dispute without you needing to go to court. So it's about saving money, so it's not too expensive for you. It's about doing things quickly, and it's about resolving issues. Say if it's a company that's not offering refunds, for example, that might actually impact a large number of people. So getting that resolved. Even if it doesn't fall under their jurisdiction, CAV will still give you advice on where to take your dispute as well. So they might tell you to contact the Fair Work Commission or the Fair Work Ombudsman. Or they might tell you to contact the Energy and Water Ombudsman if it's a matter regarding gas, electricity and water providers and billing and stuff like that. If you have an issue with food standards at a restaurant that you went to, they might say contact Food Standards Australia and New Zealand, which will provide you information on how to resolve that dispute. So even if it isn't under their jurisdiction, Consumer Affairs might be appropriate because they can direct you to experts who will resolve your dispute. However, as we have just gone over, okay, they can't solve all disputes, consumer complaints. They don't have jurisdiction over all of it. And the big one is they can't force parties to participate. They can't make binding resolutions themselves. So an extension of this is you may end up in court or VCAT anyway. And we know that that's ultimately not accessible and not ideal. Evaluating the ability to meet the principles of justice. I'm going to give you the usual. We'll flick through to the next slide in 3, 2, 1. A few things here. There's a lack of equality in that not all complaints fall under CAV's jurisdiction. And there's a lack of access in that costs are going up in VCAT because legal representation is becoming more and more common, meaning that you might be at a disadvantage if you don't have a lawyer, which means it's going to drive your costs up. However, both in CAV and VCAT, disputes are resolved by people who are experts. Therefore, the outcome should be just and fair. But particularly with VCAT and CAV, it is all about access. Okay, it's removing stress on the court system, allowing more disputes to be solved. It's CAV asking businesses to comply, which means basically there's no cost to you. There's no dispute that you have to go through the courts of VCAT to resolve. And we know that VCAT's about being accessible. It's about being informal. It's about being low cost. It's about being quicker. All things that promote access. Pretty simple in terms of getting you to look at some scenarios or find more information. I would go to the Consumer Affairs website and they can talk to you about, they've got some really good sections on how they resolve disputes or who they might refer you to. And VCAT has some wonderful sections where they teach you more about the way they resolve disputes and the options that they have for those and their different lists. So particularly sections on VCAT that are like what to do if you have a dispute, and you can sort of go through and see what you would have to do. So our essential question today for 3.2.4, not 5, as I said in my intro. Do you know what institutions exist to help an individual resolve a civil dispute outside of the courts? Hopefully now you can say that there's Consumer Affairs Victoria, which resolves or deals with consumer matters, and may get businesses or ask businesses to comply. And if not, you might need to take further action. Or you can talk about VCAT, which is a low-cost alternative, a more timely alternative to using the formality of the courts. Leave a rating below, leave some comments on how this has helped you, and don't forget to, feel free to email any questions through or feedback through to the Legal Studies Guy at gmail.com or leave it on our Facebook page. I hope you're having a wonderful holidays, term 2, wherever you're at when you're watching this, or exam preparation. This has been another video for the Legal Studies.